Well, thank you so much, everybody. Thanks for spending some time this afternoon to really think about some of these important legal issues that are out there for us, in this world of, technology and the legal issues that are, percolating and causing us concern, and also the things that are helpful and good. I know that as an attorney, sometimes we can focus on where we get in trouble. But I think it's important to take that step back and think about, how do we do some things right? So in our conversation today, I really have three broad conversations that I want to have during our time together. I want to have a conversation about data privacy and data security. And again, really from that legal perspective and some of the key reminders, and maybe some good examples of situations that might arise within the school setting, both super high tech and maybe not so high tech privacy and data security concerns, and how we walk through them and manage that. I want to have a little bit of a conversation about AI and where that's leading us in various ways, the good and the bad, and start to predict some of those things that we need to be ready to address going into next school year. And then just some continuing evolution in social media and where we're at with what courts are having to say on a variety of fronts that we need to be keeping in mind from the school setting. But let's start with that first issue, of data privacy and data security. And the headlines don't stop. And certainly I could have just as easily taken some headlines from Illinois, but chose not to do so because we always want to, maybe not pick on our friends and neighbors, but there's a lot going on out there where ransomware attacks and other types of concerns are certainly being of increasing concern in the K-12 world, right? And we have to be ready for that. And that's why I think it's important that we think about that overlap that exists between our data security processes and procedures and our data privacy pieces to that. And both play a role, and both are slightly different. And I think that making sure that we're not just getting legally compliant, but being proactive and looking for where those concerns might be arising is important for me. And so when we start thinking about where are all those places, we're starting to see, lots of situations where various forms of human error are leading to those cybersecurity breaches, the vast majority of them, And I think making sure that staff are well trained to look for and avoid ransomware and the more sophisticated versions of that are out there, with some of the more sophisticated phishing schemes and things that are out there, I think are really important that staff are ready to understand. Weak passwords, publicly available passwords, posting them on your computer screen, those sorts of things still are there. Always a concern when an employee goes rogue. And I'm frequently encountering that when somebody is sort of, intentionally creating problems in that way, errors where somebody just doesn't follow the policy, loses a device, mails a thumb drive and it gets lost in the mail. You end up with an empty envelope with a tear in it, those kinds of things that may not be the high-tech hacking, but still certainly creates a data breach that we have to be aware of, and that our vendors play an important role in that as well. When we look at the annual report on the state of K-12 cybersecurity, some of the concerns really start to look at vendors and other things. And at least 75% of the data breaches affecting K-12 schools in the United States involve their vendors and other partners. So whether that is some sort of ed tech vendor or some other partner like, government entities, others that you're sharing information with, those factors that are out there. And so that fact, that reality is part of why our SOPA compliance is so important, so that we are making sure that all of the other third parties with which we're sharing student data and information that we have the right agreements in place to protect us from liability and have processes that are going to be more likely to keep our data protected and secure, and that those entities are also implementing those reasonable security measures that are important for us. And so I think that when we were all in that run up to SOPA's implementation, now almost 2 years ago, believe it or not, we were, focusing on what we got to do to get compliant, to hit the ground running in 2021 after July 1st, 2021. But, the statute didn't stop at that point, right? We have to stay proactive in addressing these concerns. And part of that is making sure that we are training and communicating with all employees about their role in that process. Our system is only as secure as its weakest point. And so have we identified where that is and trained our employees on how to make sure that they are identifying social engineering attacks, how to handle data, what might lead to unintentional data exposure, and how to report those instances, and really have that type of training and awareness program across the board. Because we've all got employees who are probably creating some of those human errors that are leading to the breaches in our system, or creating the weakest links in our system. And we need to be proactively looking for who that is, and getting them the training that they need, and putting in place the backups to make sure that that doesn't happen. And I still see this being a frequent flyer problem, because a lot of educators still want to just download a new app and use it, even though that vendor may not have been pre-approved for use. We may not have a SOPA compliant agreement, and it may not have the data privacy protections that we need to expect from all of our third-party vendors and operators. And I think that the message is still not trickling down to all of those frontline staff members who have devices that they are using student data with, and how that plays out for us. And obviously, the LTC has a lot of resources available to be able to help manage that system. But at the district level, we've got to be very careful about how we are, following through on that, and having all of our employees do that. And I think there's some key components here that we want to make sure that all of our employees are aware of, that they understand and respect the reasons why we only can use approved operators and vendors, that they are implementing those reasonable security practices wherever they might be using and storing student data. And I think that this is something that's been a frequent flyer issue as more and more employees work remotely. The importance of the security in their other systems they might be accessing, their home networks and other things, become really important for us. And so I am sometimes concerned that districts have adopted written policies and procedures, like the standard set of policies and procedures from the School Board Association's Press Policy Service, and then they sort of set it and forget it. We adopted the right set of policies, and now they're going in a binder. And we've got to do the things that it says we're going to do. When we don't follow our own policy, that's when liability can accrue. And so, for example, that policy language says that each district has to designate which employees can enter into those agreements. And, the associate procedures require you to specifically list those employees. And, are we doing that? The default procedures also talk about having an ed tech committee, whose job it is to determine whether or not the vendors and third-party apps and other things that district employees want to use, are appropriate, meet the reasonable security practices, can be, we can enter into an appropriate SOPA compliant agreement with them. So those things are really important for us to use our ed tech committee to be able to do that. So I want to make sure that we are continuing to be proactive, so that our ed tech committee is prioritizing that security program and being proactive about looking for where those risks might be, and where is the weakest link in our system. Have we trained employees in a meaningful way, where they actually understand what you take away? If we've got employees who may not be as tech savvy, Are we training them in a way that's going to be practical and meaningful for them? And are we keeping our vendors and operators accountable for maintaining those safeguards, not only in our written agreements, but also in practice as well? And recognize that, cybersecurity risks advance at lightning pace. So once we have the right system, tomorrow there's going to be a new thing. And are we continuing to reassess and reevaluate that? And so we need to look at our network design, what software and applications we're using, how are we transmitting data, and do we need to have more encryption and safe storage, and those types of things. I think that's really important for us. And then, of course, looking at those physical safeguards. How are we physically storing data? And how do we prevent intrusions and protect against unauthorized information? And so I think we've got to think practically about that. And so I think we've got to talk to school staff in ways that start to make sense and start to hit some of those real key things. When we're using our personal device, have we enabled basic security features like a Face ID or fingerprint, or using a PIN to access your phone or your computer, so that not just anybody can pick it up and access that information and be pre-logged in to things that are secure? Are we using unique passwords for all of those access points? We change the default password from our home router and those types of things. Have we chosen passwords that are actually strong? And using phrases, the more complex, the harder it is to crack. And so are we using those appropriate passwords? Is our home Wi-Fi set up securely if we're going to be accessing, the school's network and data? And when we are other places using that free Wi-Fi at Starbucks, right? Those are inherently sometimes unsafe, and we want to make sure that we're taking those extra measures. Also, in fact, when we're using web-based cloud storage, whether that's our iCloud or Dropbox or Box or all of the various forms that exists, make sure that we're also, even in our Google Drive, how are we, making sure that it's in the right place? It's not in our personal account, it's in our school account, all those things that we want to make sure that we're doing. But again, as technology moves forward quickly, we've got to be able to come back and assess, are we, have the right situations in place? And then I think we can have other practical conversations with employees too, and think about some of those lower tech confidentiality concerns. If we're working remotely, who's around and listening? If I'm in an IEP meeting by Zoom, do I have a spouse at home, my kids at home? Is Alexa listening to me? I don't want to say her name too loud because I don't want to activate everybody's devices, right? So how do we think about that privacy? Are we sharing our device? Are we letting our kids play games on our iPad that also accesses the school's data? Those types of things that are important for us to keep in mind. And then that just real low tech confidentiality concern, you just leave that student file on the dining room table where, anybody who walks into your house might be able to see that, who may not have access to that. So we want to really think about how we are broadening that scope, right? And I think that's sort of the next level to make sure that we're training staff to be vigilant about that in all settings where they might be accessing data. Just some purely hypothetical examples where we can see various forms of human error creating cybersecurity risks for us. For example, over the weekend, a school administrator's car is broken into, several items stolen, including a laptop that had student data. And while the laptop was password protected, the data is not encrypted. What should we have done? What can we do? Do we have a system in place for that? And how are we safekeeping things? We've got a school administrator who believes she may have opened a phishing email and thought it was an email from the superintendent and asked her to click a link. And now she realized maybe we've opened ourselves up to a phishing attack. And, do we have then a plan in place? Do we know what to do next? And so that we can move quickly to stop that harm and get our system back to being secure. Do we have, even within a secure system, access that goes too far under FERPA or the Student Records Act? If we've created a Google Doc, but then everybody in the school district can access that Google Doc, do we have a FERPA issue? And are we accessing it from unsecure locations? That also calls into question the privacy of what we're talking about. Or again, getting super low tech with some of our data privacy concerns here. What if you're reading a student special ed evaluation report on your phone and the person standing behind you in the line checking out at Walmart is reading it over your shoulder? You know, are we in a private setting to be able to access private information? You know, are we using unsecure, never going to be SOPA compliant avenues for that communication, like Facebook Messenger, for example, or other social media platforms? You know, are we letting, again, our kids access information on those computers? I think those are all just practical considerations that I want to throw out there for us to be actively thinking, because in each of your districts, you've got different weak points, right? Not every district's weak point is the same. And so what I think is important for our IT folks in schools, for our ed tech committee, for our administrators, to really be coming back as part of our ongoing reevaluation of this process. Where are those weak points and how do we fill in those gaps to strengthen our system and take away some of the weaknesses that might be there? And I think that that's important. So those are some things I want to make sure going into next year we're prioritizing and thinking about, so that we can get the right information to the right people in a way that's meaningful and useful to them. And I think that's important. I do want to mention just one other case that's out there pending. If you joined me earlier this year, you heard me talk about this case, but I do want to remind ourselves that there is at least one case out there pending, and so far only one case pending out there where SOPA is an issue, and it's kind of an interesting hybrid set of information. So this case is actually a lawsuit brought by a few sets of parents in Illinois against Google, specifically related to the school issued Chromebooks and whether they violate their child's privacy rights, specifically under the Illinois Biometric Privacy Information Act, or Biometric Information Privacy Act, sorry. And the concern here was, hey, you know, these Chromebooks are collecting the student's voice, their faces, you know, there's Face ID, there's other information here that is being collected by Google for using their Chromebook. Now, this lawsuit is not against the school district, although I think that's interesting. It's against Google, but it is an Illinois school case. And you know, the court here earlier this fall granted in part and denied in part the motion to dismiss filed by Google, and kind of, you know, looked at this issue. You know, hey, there's definitely some biometric information being collected here, and that maybe we didn't have the right consent in order to do that. Google said, hey, because of the federal COPPA and the state SOPA statute, you know, we're compliant with those, and that preempts the Biometric Information Privacy Act. But the court said, no, we're gonna let that case move forward. Right? We're not gonna dismiss it on that basis, because SOPA is a new statute, and we're gonna let this play out and go to discovery and see where it goes. And that's where it sits. You know, looking back over the court docket, there's not been any further movement in this case. It is still pending. So I suspect the parties are going through discovery and perhaps engaging in either settlement conversations or preparing for trial at some point. But I think it does, again, recognize that these are concerns that are out there, and that parents certainly have those concerns about that, and we have a lot of legal requirements that come into play. And so when we start to think about the interesting interplay here between things like the Illinois Biometric Information Privacy Act and its very strict requirements for any use of biometric information, and the federal COPPA protections and our state, you know, SOPA statute and the data privacy requirements that are there, it creates this interesting set of layers of protection. And I think it's important that as school districts, we recognize not only that we have these multiple layers of protection, but that we're paying close attention to it. And I think that Biometric Information Privacy Act issue is interesting, because there's more than one reported case out there where that's been a school issue. Not yet directly against the school, but against others. There's obviously this case against Google. There's a case a couple of years ago against Six Flags, where Six Flags was collecting, you know, as part of the ticket, the fingerprint, without the right parent consent to take that biometric privacy, and Six Flags had to pay damages. But that was a school field trip where that occurred, because the parent wasn't present to consent as required under that statute. So, litigation in this area continues, and so we'll pay close attention to it to see how it plays out. But I think it's an interesting one to pay attention to. So that's sort of first topic as we walk through and think through these issues today. The second one is I want to spend a few minutes just talking about the good and the bad of artificial intelligence and where we're at on that. And we've seen this in different ways. Just this week, there was a Senate hearing on issues with AI, and had the CEO of ChatGPT testifying in Congress and sharing concerns himself, right, about where this is going and how fast it's going and what that could mean for us. And I think that we're starting to see this play out in the school setting in several ways. And so I want to talk about some of those. I mean, there's the good part of it, but then there's also the questionable parts of it. We definitely know that plagiarism has become a big deal. Students across the board are handing in essays that they didn't write, that were written by ChatGPT or some other, AI platform. And that's certainly a big worry, is that a substitute for students learning the underlying content? How do we check for that? How do we prevent that? And that's a challenge. The ability to do that is a challenge. And I think that's something that we've got to be talking to teachers about and preparing them for that reality, probably updating our policies and handbooks around those types of things to make clear what the rules are, and to try and find more sophisticated ways to detect and respond to that. I think that is certainly a concern. There are certainly ethical questions about, because oftentimes the AI is a mixture of other people's work and there's not really a credit for the creator. So who owns it? The copyright issues at play. So those ethical questions are certainly there. It certainly is an opportunity for bias or misinformation. And I'm seeing this in some real practical ways that are not unrelated to issues related to deepfakes and how they've been used to bully and harass. We've seen, in school situations, a variety of things where that's been problematic, where the use of deepfakes have been used to bully and harass others, where people can use, some form of AI to develop videos that start to look like somebody else and look so realistic that we can't tell. There have been issues where people have created some form of, sexualized content using people's pictures. So you can take the picture of a student, for example, and AI will create a pornographic video that it looks like they're engaged in sexual activity, but it's all AI generated. It's not real. We've had cases where, people have created deepfake videos of teachers and administrators to look like they're saying or doing things that might be offensive, and it turns out they're not real. They're deep fakes, and that is a problem, and so how do we address that? And I think that we see this again, threats, revenge porn, is it a parody particularly of the First Amendment, or is it in fact creating a material disruption? And I think the answers to those courts are going to struggle with. There's not a lot of case law yet out there on these topics. There are a few cases around the country, more in the criminal context, where maybe somebody has engaged in maybe a threat or some form of fraud, where maybe there's been criminal cases brought related to that. But I do think it is really interesting for us to be on the lookout for that. So with the significant and quick increase in these issues, in the K-12 context, I think as we go into next school year, we need to be thinking about, should we be updating our handbook language? Should we be updating our training for teachers? Should we be updating our, internet safety curriculum for our students? And how does that play out? And I think those are some important considerations that we have to keep in mind. I see a question here, what about in the elementary setting? right? It's my understanding that AI tools as of today have terms of service that have an age requirement of 13. But obviously, as this changes and the possibility of integration with tools like Google Suite, we may see this change. But what about younger learners? Yeah, I think, we're going to see this certainly much more frequently with older students, because older students are going to be the ones more likely using that technology and being able through the terms of service to do that. Although I think that that's not always going to be possible. I think about my 5-year-old daughter has a friend who has a cell phone and who uses it, and she's not even really a reader yet, but she knows how to make a voice message and send it to her parent and vice versa. And I just, to start to realize that we're at that young age, we're seeing students very adeptly use that. I don't think we can just say it's not going to happen until we get to 13. Now, obviously, I think the middle school and high school concerns are much greater. I think student sophistication in using it at older age is greater. The likelihood we're going to see it at a more frequent rate is certainly there. But I think we've got to be prepared for it at all levels, because we'll see it in different ways. And I think that we, just like we're maybe not seeing social media threats the same, for example, at the lower grades as frequently, it doesn't mean that we don't have policies to be prepared for it. But it's probably going to be a rarer instance that it occurs. I had kind of an interesting, and maybe this is happening today for all I know, a meeting last week where I was going to do a special ed roundtable. And at the beginning of the roundtable, I was joined with myself and 4 AI bots to start the meeting, where instead of coming to the Google Meet, those people just sent their AI bot to take notes. So instead of being there and listening, they're just getting a set of notes generated by AI from the meeting and not having to come to that. So who knows? Are some of you who are here today not really here today? Did you just send your AI bot to listen to Brandon and take notes for you? I don't know that that's how I would learn the best, but I recognize that those types of things we're starting to see. And so do we have situations where students are not actually showing up to a remote class, they're just sending their bot to take notes, or other similar situations like that? Well, again, we're seeing this grow and the technology is evolving and emerging. And I think we just need to be on the cutting edge of that, because as school districts, we are going to be faced with those things. So many issues as our society evolves, we get to be the front line for, the book wars and the book bans and the book bans. Those are things we're on the front line of, and other culture war issues. And I think that when it comes to things like technology, and especially AI, where AI can have an impact, we're going to see that. And I think that there's some good things to be said, right? I am certainly not here to suggest that AI is only negative. There are lots of great things. And I think as that technology continues to improve, we will see some great practical application for a lot of those tools. But, we can also see how it's used for harm. Just like in the data privacy setting, people are actively trying to steal information because it's worth stuff out there on the black market, and they're making money off of that. And I think that we'll see this again in various ways in the school setting, and I want us to be prepared for it. So I encourage you on this AI issue to start really thinking about this from a couple perspectives. One, what do we need to update in our policies and our handbook language? Where are there some gaps when it comes to understanding what students could be disciplined for, what is acceptable conduct? And then I think we also have to come back and think about, so what does that need us to be able to give our staff training on to understand that in some of these areas? And then, how do we incorporate that into what we're teaching students and in that regard? And I think some of these issues, like the issue of parity, is going to be one that courts are going to wrestle with. If you create there are those cases out there that suggest, creating a fake social media profile of a school administrator might be a protected parody if it's obvious that it's a parody. But with deep fakes, is it obvious that it's a parody? Was the intent to defraud, or was the intent to create confusion and disruption? I think those are questions that courts are going to have to answer very plainly for us to feel very certain about where that goes. But regardless, I think those are things we've got to be prepared for. And I want to make sure that we're thinking about that going into next year. All right, so the third area I want to spend some time talking about today, and then if you guys have questions, please don't be shy about putting those in the in the Q&A, and happy to answer them. We continue to see some evolving social media case law. And again, just by way of quick review, we see that in 2021, the Supreme Court decided in the Mahanoy case, that there's limits to when and how school districts can discipline students for their off-campus social media conduct. But there's also times when it definitely falls within the school's jurisdiction. And they definitely identified 4 areas, right, where we'd see that: serious or severe bullying and harassment targeting individuals, threats aimed at teachers and other students, failure to follow rules concerning remote learning, and cybersecurity breaches. When those things are happening, right, those are things that the school may be able to regulate or issue discipline for, as we think that through. And I want to talk about a couple cases that have, I think, given further clarification to how the Supreme Court decided Mahanoy and where that goes. One of those was decided earlier this school year, the Chen versus Albany School District case from California, a Ninth Circuit decision in late December. And this case involved a situation where you had a student create a private Instagram account where he posted some very inappropriate and offensive things. Now, his defense was, hey, this was a closed private account, so only my approved followers could see it. And I only ever intended for those 13 followers to follow it. And so the 2 students who are at issue in the appeal are the student Epple, who created the account and authored most of the posts and images, and then another student, Chen, who was one of the people who followed the account, who was also disciplined. He liked some of the post. He commented on one post. And so the issue is, was that protected speech under the First Amendment, or was that conduct on that private Instagram account enough to bring it within the school's jurisdiction? And the Ninth Circuit agreed to the lower court that, hey, this impacted school, and under the Mahanoy case, this district could discipline. So the main thrust, or some of the major concerns, were that there were some very targeted racist posts and language targeting African-American students at the school, and sort of making fun of their race and various things. And of course, as always has happened, it wasn't private for that long, right? Well, actually, it was private for longer than I might expect, but eventually it's shared around the school, and obviously it creates some great concern. And the court says, look, as we analyze this, the first thing we have to ask ourselves is, could the district have punished students for this conduct if it had been made on campus? They said these things at school during the school day, and the court says, of course, right? These are posts that use some violent imagery, that they are targeted at specific individuals using deeply offensive and insulting words. So if somebody had said this to another student at school, plainly this would have been within the school's ability to discipline. So does the fact that it took place off campus change things, or was there a sufficient nexus or connection back to school? And the court here said there was a sufficient nexus to school to justify discipline. The court said, given the ease with which electronic communications may be copied and shown to other persons, that it was plainly foreseeable that the student's post would ultimately hit their targets, with significant impacts to both those individual students and the school as a whole. And that while the student emphasized he didn't intend for anybody to ever see these posts, the court said, though, quote, but having constructed, so to speak, a ticking bomb of vicious targeted abuse that could be readily detonated by anyone following the account, he can hardly be surprised that a school did not look the other way when that shrapnel began to hit the targets at school. So clearly, there is the ability to do this. And in fact, the court went a step further in saying the school district has a legal obligation to protect other students from harassment based upon race, among other factors, and that it could have been liable had it not, responded effectively and promptly to the racially hostile environment that these posts were creating in the school setting. And that while the student is free to express offensive and unpopular viewpoints, that does not include a license to disseminate severely harassing invective targeting a particular classmate in a manner that is readily and foreseeable transmissible to those students. So I think this definitely opens the door. We know that in Illinois, the school code says that our bullying policy has to include cyberbullying when there's an impact back at school. I think this case is an example to show where and how we have the responsibility to address that. Now, the other student in this case, Mr. Chen, said, hey, but I didn't make any of those posts. All that he did, right, was like 2 posts that were racist in nature and responded to another student's comment at one point. Another student posted at one point on one of his posts something to the effect of, hey guys, this is not cool. This is super racist. Like, you should stop this. And Mr. Chen responded to that comment with 2 words, F you. So was that enough to justify discipline? Court says yes. The court says that he is akin to a student who eggs on a bully who's tormenting classmates, and that affirmative participation exacerbated the abusive nature of this. So found that was also enough to get us there. So I think cases like this tell me the courts are going to be willing to say when the evidence is clear that this is targeted harassment at specific individuals and it's impacting school, that's not going to be speech as protected by the First Amendment, and that we have the ability and in fact the responsibility to address that. Another recent decision that I think is also relevant here is on that Mahanoy prong of what's a threat of violence. And this case kind of covers both the issue of the threat of violence, but also the harassment targeting individuals. So this is also a Snapchat case. This one's out of Katy, Texas. The Fifth Circuit Court of Appeals just decided this here at the end of March. And here you've got, and of course, this is such a Texas case. This is the most Texas of Texas cases. You got 2 different rival football teams who are at the same Whataburger and who end up in a Snapchat argument while at the Whataburger. I mean, does it get much more Texas than that? And of course, you can see here the language used included a threat of violence that will put your, MF ass in the hospital, and the use of the N-word. So those things together say, hey, we've got some concerns. Now, what makes this case interesting is there was another student who recorded that and sent it out to others, and the issue here was this student didn't intend for this to be publicly made available. Nevertheless, it was, because when you put stuff on social media, even on Snapchat, what's to prevent your friends from taking a screenshot or other things? That's what happened here. And originally, the student thought he was just going to get a 2-game suspension and no longer be team captain on the football team. But, it kind of, moved on from there. But ultimately, this student sued saying, hey, that was my First Amendment free speech rights. But the court ultimately dismissed this case on the grounds of qualified immunity, and said so by saying, because all of this happened in 2019, even though it's just now getting to court, we didn't have the Mahanoy decision yet, so maybe we wouldn't say the law was clearly established, even though we might be able to say that it's clearly established now. And so I think the fact that this situation predated the Supreme Court decision Mahanoy was important. But nevertheless, the Fifth Circuit affirmed, saying there's enough here to say that this was an act of threat of violence, that this was harassment targeting an individual, and therefore, let the case, stop on that basis. So an interesting one just decided. The one other case I also want to mention is another sort of, is it a threat or not a threat case? Again, a Snapchat case, this one from Pennsylvania, where a student posted the lyrics of the song Snap by the band called Spite. Any Spite fans among us today? But ultimately, the school thought, hey, that might be considered a threat of violence because the Snapchat post used the phrase, "I will effing kill all of you." Now, that was not directed at the school or an individual. It was just a statement in a Snapchat saying, "I will effing kill all of you." Student was arrested, charged, subject to psychological exam, expelled from school. And, there were a lot of people anxious and upset about it. People didn't show up to school. But the court said, nevertheless, we think this is constitutionally protected speech. And I think the careful, interesting balance here on this threat analysis is the court said, a short-term suspension while the school investigated would have been reasonable. But eventually, the threat assessment team, law enforcement, everybody else, psychologists all agreed this was not a threat. It was not intended to be a threat. It was misinterpreted. He was just posting the lyrics of a song he was listening to. And that was not directed or targeted at the school, and therefore expelling the student at that point violated his constitutional rights. And I think the language the court uses here kind of captures that balance. The court said, quote, "Public schools may certainly take appropriate good faith steps to protect their communities in fluid situations where it's unclear whether the student's off-campus speech indicates genuinely harmful intent, as neither the First Amendment nor the state constitution require they sit on their proverbial hands until that threat comes into fruition." And I think here what the court is saying, hey, yeah, this concerns you. It could have been concerning. You needed to figure it out. So a short-term suspension while you did your threat assessment process and figured out what was going on, that would have been constitutionally acceptable. But once it was determined that the student was not a threat, it was not intended to be a threat, the Mahanoy case says it's got to be a threat aimed at teachers or other students. This was not that, and therefore it's protected by the First Amendment. So I think that's what we see. So when we start to look at what are some of the key themes from the cases over the last couple of years since the Mahanoy decision, is I think there's clearly an answer that courts believe there's some sphere outside of school where students should be able to say whatever they want, subject to parent discipline, but over which the school doesn't have control. And that the fight over vulgar language is over, right? The vulgarians have won, and that's where it lands. And so many of these cases that have been decided in the couple dozen cases we've seen over the last 2 years really are more about extracurriculars. Among Mahanoy is, the Katy, Texas cases. And I think that there are a lot of districts getting in trouble for having vague or overly ambitious extracurricular codes that might be punishing students for protected First Amendment protected speech. And I think that having, athletic codes that say things like athletes should be good people is fine as an aspirational goal. We got to be careful about how we're using that to discipline folks, given where the courts are at on this. I also think that courts are saying, hey, we think that if it's truly religious or political speech, there's sort of an extra layer to justify intervention. And that is certainly an area that we want to take note of. And I think that when we start talking about where courts are at on this, courts are sort of looking at the totality of the circumstances. And I think when we look at all of these various cases from the various circuit courts over the past couple of years, I think there's some factors that are important as we're looking at what we mean by the totality of the circumstances. I think one of those is, was it reasonably foreseeable that the speech would reach and impact the school? There are multiple cases where that has been a factor the court has looked at. Was it intentionally directed at the speech at the school community? So was it something that was supposed to be about school? Was it specifically the school mentioned, people at school mentioned, directed at the school? That's part of the factor. What is the degree and likelihood of harm to the school? So is it causing harm or causing us to predict harm? I think that is there. And then, of course, whether the speech is primarily about a political, religious, or other sort of message that's protected, or is it targeting a particular student or teacher in a manner that is readily and foreseeable, transmissible to those persons, again, less likely to be protected in that situation. So I think those are some factors we've got to look at. So I think that, we've got 2 years of court decisions on the student social media piece after the Mahanoy decision. And I think those decisions are causing us to take a step back and say, we need to really look at the real facts. I think that a key theme for me coming out of these cases, and I think it's sort of reflected here on this slide, is that we can't just paint with broad categorical brushes. Like, this was a threat, so because we can reasonably interpret to be a threat, we can automatically do X or Y or Z. And I think that where the courts are firmly at on when students are using technology outside of school in a way that starts to impact school is that it's going to have to look at those specific circumstances, and the facts of that case matter. And so I think we have to start to get into the role of the threat assessment team, the intent of the student, and factors like we see here from these various decisions, in making a decision about what the right thing to do is in that circumstance. And so gone are the days of saying that could be interpreted to be a threat, so it's going to automatically be handled a certain way. And I think we've got to have some nuance and specificity and recognize the unique circumstances of each case as we walk through that from the social media perspective. I think that's important for us. So those were just the 3 small topics that I wanted to mention this afternoon during our time together. So we definitely have some time for some questions. So if you've got questions, don't be shy about popping those in the Q&A. But as you type those questions in, I think that these are 3 areas where we definitely are seeing the law evolve and change, and the needs for school districts to be constantly aware of those changes important. The data privacy and data security piece and all the things going on with that. I want to make sure that we recognize the evolving nature of the danger, the increase in issues of impacting school districts, and how we stay vigilant with our SOPA compliance as we move through that and look for the weakest link in our system and fill those gaps. I think second, when it comes to the AI front, this is happening way too fast and right in front of us. And there are things about it that are super cool and I'm super excited about. And there are parts about it that scare me to death, especially as a parent. And so how are we updating our policies, procedures, and handbooks to be prepared for those things? How are we preparing our staff to handle those situations? And informing our students, teaching them some of those important things of being a good digital citizen and what that means for us. And then on the social media piece, this is the gift that keeps on giving, right? And so as the platforms evolve and as things change, we continue to move from, we had the old MySpace cases, and then we got the Facebook cases, and then we've got the Snapchat and the TikTok cases. And I think that we need to recognize that the courts are still trying to put, this evolving technology into the old categories of the First Amendment that have been around for, more than 250 years. And or nearly that at this point, since the First Amendment went into effect. So 230 some years now, right, since the First Amendment's been in effect. And that's a challenge for courts. And it's obviously, as that trickles down, a challenge for us as educators. And so I think having some reasonable approaches to that makes sense, where we're looking at the totality of the circumstances. And what I find to be true is in these areas where we're concerned about harassment and cyberbullying and threats of violence and all of those types of things that happen through social media, that when we have a culture of punishment, students tend to, close up, and it's harder to solve those problems. We have a culture that's about teaching and growing and intervening, and that culture of intervention, we're going to make some progress there that I think can be really helpful. And so I want to not get too rigid and instead focus on how do we teach kids to do this the right way, because that's going to impact them so much going forward. So So that's the little bit of information I wanted to share today. So I appreciate everybody hanging out. I don't see any other questions here. So Matt, anything else we need to talk about before we wrap things up today?
Well, I will go down the line here. We have kind of a smaller group, so I will go down the line and unmute everyone. If you'd like to, if you're more of a talker than a typer, feel free to just click that little microphone button on your screen and ask your question. You can also use the chat or the Q&A. Pause and let you formulate. Katie, did you have a question?
Yes. Can you hear me?
Yes.
Yes.
Okay. Just to clarify what you addressed for the SOPA slide in regards to forming a tech committee that would evaluate, and that was in press. I actually got this information, I think from you, Brandon, from a previous webinar, and went to my superintendent and we looked through press. I was unable to find that. And I don't remember that specifically from the training that I did on SOPA. So I was just going to see if we could speak to that a little bit more as to what that involves.
So when we look at that language there, within that press, that's within the administrative procedure. So not just the main policy, but you got to dig to the next layer of that administrative procedure. And that's what's in their default language. And not every district has adopted their default language. So, as administrators and boards are looking at that policy and procedure language, and they're working through that press policy decision-making process, there's some optional language. Yes, I want this. No, I don't want this. And if you choose not to use an ed tech committee, then that's going to fall back on the superintendent to fulfill those roles, or the privacy officer to fulfill those roles.
Okay, that makes sense. We're a smaller district, and so it's pretty much him and I that go through this process, at least initially. So it sounds like we're checking the box. We're just doing it in a different way.
Yeah, and I think, there's a big difference between a small district and a huge district in terms of how to make that work and where to assign that responsibility and who has the expertise to do that. And I recognize in many small districts, we get to wear lots of hats. And sometimes bigger districts, we get to have a narrow band of responsibility. But I do think in a lot of districts, having a committee helps establish that buy-in from teachers and others when you have to start answering as to why we're doing things a certain way. So I would at least think about that.
Okay, thank you. I appreciate your feedback.
Sure.